if you have a problem with me for some reason on that basis, speak now or forever hold your peace.
No issue with that.
Okay.
Your Honor, of course, we have no problem.
Okay. Thank you. Hear from the appellant.
May it please the court, I am Robert White here on behalf of the appellant, Mr. Kenneth Brooks, and I would like to reserve 5 minutes of rebuttal time.
5 minutes, that'll be fine.
This case centers around the trial court's granting of a motion for summary judgment on behalf of appellee Whaley Construction. Briefly, on May 19th, 2021, Mr. Brooks, the appellant, had issues with his vehicle. He stopped in the city of Maryville and was walking by foot through a grassy median in an area with a construction zone where Whaley was contracted with the state of Tennessee. He slipped and fell over a signpost that was just outside a silt fence maintained by Whaley. The issue in this case, I would respectfully submit, is was there a duty on behalf of Whaley to Mr. Brooks in the area where he was injured? But that is where I would submit that the material dispute of fact, which of course is required to go forward, is the proof in the record by way of Mr. Brooks' declaration of facts indicates that although he admits it was outside the silt fence, that there was signs to indicate that work was being done outside of the silt fence. So we would submit that that creates a genuine issue that a jury should decide, and respectfully not the trial judge. Where there is some uncertainty over whether there may be such a dispute, of course, the trial court is to overrule any motion for summary judgment, and that's the Evco case, as cited in a brief submitted by Mr. Brooks. Of course, the facts are supposed to be viewed in a light most favorable to the party.
Excuse me for interrupting, counsel. Was there additional evidence presented with respect to who maintained control over this area where the injury occurred?
There was the declaration. There was a letter by the state of Tennessee which indicated that Whaley was responsible, attached, and
would that letter have been admissible evidence in this case?
not as presented by way of the format by which it was before the court, but we submit the court doesn't have to rely on that to determine there was a material dispute of fact based on the declaration. Of course, this was not a situation where we would submit that the inferences could be drawn from the uncontroverted facts that were so certain that reasonable people could not agree on them. And again, our position is that the key fact would be who had control in this area, and that it wasn't sufficient simply for Whaley to aver that they only controlled the area inside of the fence when there was evidence presented to indicate that that was not the case.
Counsel, you said there's, I think in your brief certainly does talk that there was proof presented to the trial court that there were signs of construction, and not like the sign we're talking about laying on the ground, but in the case of construction outside the silt fence. What was given to the trial court specifically on that?
The declaration of Mr. Brooks and his observation that there were piles of dirt that had been recently moved and things about in the area of the median, which
Outside the silt fence?
that's correct. And so that's our position, is that it's sufficient for the purposes of summary judgment, nonetheless, that this area that Whaley was under contract with outside or in the median can't be simply brushed away by a motion for summary judgment in saying that, oh, well, we're only responsible for the area inside the silt fence, when there was proof presented to the contrary. So that is essentially we would submit the seminal issue that a jury should be allowed to decide whether there's a duty and control in this area. And if there are no additional questions, I'll yield.
I hear none. Thank you.
Thank you.
We'll hear from the appellate. You have your time for rebuttal.
May it please the court, I'm Janet Hayes, here today on behalf of the defendant appellee, Whaley Construction. The court has now obviously had an opportunity to review the plaintiff's brief and has heard arguments of plaintiff's counsel. And I would ask the court to not only consider what was said, but consider how it was said, and perhaps most importantly, consider what was not said. In the plaintiff's brief, the arguments are characterized as allegations. Plaintiff's counsel says that Whaley Construction may be responsible. He characterizes it as hardly a spurious or far-fetched possibility, and then goes on to say that the trial court should have considered it if it was a possibility. Again, plaintiff's counsel's arguments are rooted in allegations. What is missing, and what you don't hear, is citation to specific admissible evidence in the record that establishes facts supporting those allegations. And there are no facts supporting those allegations. As noted, this case was decided on summary judgment, and the Tennessee Supreme Court, in the seminal case on summary judgment, Rye versus Women's Health Care Center, stated that to survive a motion for summary judgment, the non-moving party, and I quote, may not rest on the mere allegations of its pleadings, but must respond and, quote, set forth specific facts at the summary judgment stage. Here, the plaintiff failed to adhere to the requirements of Rule 56 and failed to follow the mandates of Rye, and for that reason, the trial court was correct in granting summary judgment. Now, as this court is aware, there are essentially two circumstances where summary judgment is appropriate under Rule 56. The first is where the non-moving party fails to establish an essential element of his claim. The second is if the moving party offers affirmative evidence negating an essential element of the claim. We assert that not one, but both circumstances are present in this case. And first, I'll address failing to establish an essential element of the claim. I think we all understand the facts of the case. Plaintiff claims that he tripped over a signpost that was sticking out of the ground. I think we all agree an essential element in order to hold Whaley Construction liable for that would be to show that Whaley controlled the signpost, created the dangerous condition, or controlled the dangerous condition. There are, however, no facts in the record to support that allegation. It has been mentioned, the only proof in the record that has been referenced is a declaration submitted by the plaintiff himself, and there was a question about that declaration. And I'd like to give you 3 reasons why that declaration does not create a question of fact. First, the declaration was never properly presented in the context of Rule 56 to the trial court. When the defendant filed their motion for summary judgment, we filed in accordance with 56.03 a statement of undisputed material facts. As the court knows, it's the plaintiff's obligation then to respond to that statement of undisputed material facts. In the plaintiff's response, there is no reference to a declaration. And in fact, there is no reference to any evidence that we could find. There's a claim that certain facts are disputed and a reference to an unknown Exhibit 4, but we were unable to find Exhibit 4, and if you'll read the transcript, the trial judge was unable to find the alleged evidence that created the question of fact. And the trial judge questioned counsel about that and gave opportunity for that to be presented, and it was not. The obligations of 56.03 to put forth evidence to create the question of fact are mandatory obligations. And this court has said in prior cases that it is not the duty of the trial judge, nor is it the duty of the appellate court to search the record to try to find a disputed fact. It was the obligation of the plaintiff to present questions of fact. And because the plaintiffs did not, it was perfectly appropriate for the trial court to accept the Rule 56.03 statement as offered by the defendants. But even if the declaration had been properly submitted, it still does not create a question of fact. As mentioned, the declaration includes an exhibit, a letter, and that letter was not admissible evidence. Again, going back to Rule 56, Rule 56.06 requires that evidence be admissible in order to be considered at the summary judgment stage. And as counsel has conceded, the letter that was written by the state of Tennessee was not admissible evidence. That issue was raised in the trial court and is included in the transcript of the proceedings below. So this declaration was not referenced in creating a dispute of fact under 56.03. It included a letter that was not admissible evidence, so it should not be considered. But let's take it one step further. I said I would give you 3 reasons. Even if the declaration were there, and even if the declaration included admissible evidence, substantively, the declaration still does not create a question of fact. The plaintiff's testimony in the declaration, as has been mentioned, is that he saw piles of dirt. Now, there are photographs in our brief, and I will discuss in a moment some more details about the construction site, but it is a grassy median, and there's a silt fence that is clearly visible in a photograph taken at the time of the accident. The construction project was above the silt fence. The testimony in the declaration from the plaintiff is that there was a pile of dirt below the silt fence. Again, I ask the court to hear what is not said. And what is not said is, where was the pile of dirt in relation to the signpost, number 1. Number 2, and perhaps more importantly, who created the pile of dirt? There is no evidence anywhere that someone from Whaley Construction created the pile of dirt. And going one step further, if there were a pile of dirt outside of the silt fence, and even if Whaley created it, how on earth does that relate to the existence of a cut-off road sign post? How does that show that Whaley Construction somehow cut off a road sign in a different area? The existence of the pile of dirt, even if the court should consider that evidence, is irrelevant and does not create a question of fact as to whether Whaley Construction controlled the place where the road sign is.
Did the declaration say anything about these piles of dirt look like they'd been recently?
Yes, the declaration, as I recall, the declaration, the plaintiff's observation was it looked to him like the piles of dirt were recent.
Let me ask you a couple of questions about Mr. Park's declaration.
Yes.
at the time of the alleged accident, when he fell,
Yes.
Whaley didn't have control over, responsibility of. And then it's the only, I guess I keep coming back to the phrase is at the time of plaintiff's fall or the time of the accident. Well, the signpost, something happened to the signpost before the time of his fall. Did your client present anything? They certainly, the declaration covers about at the time of the fall, they didn't have custody, control, or possession of that site. Did they present anything saying they never did?
I don't know that the declaration uses that language. It certainly would be intended to say at the time, and I think before the fall. I don't know about afterwards, but I would, in considering whether the plaintiff satisfied proving an essential element of his case, and I want to talk about the Parks Declaration, and I think it is important, but you don't even have to get to the Parks affidavit. It was not Whaley Construction's burden to negate an essential element when the plaintiff never established it to begin with. There is nothing in the record that the plaintiff has presented that said Whaley cut the road sign or controlled the area where the road sign was. And I'll go ahead to your point, the Parks affidavit, I would say even though the plaintiff failed to establish an essential element of the case, Whaley did offer the Parks affidavit and offered affirmative evidence that I argue would negate the fact that, or the argument that Whaley controlled the signpost. The Parks, Mr. Parks, Michael Parks, was a superintendent on the project. He was the person who had the knowledge and the control over the project. His declaration makes the unequivocal statement that defendant did not create the signpost, and the work that was done by the defendant did not involve removal of the road sign. As you can see in the briefs and as it was presented to the trial court, there's photographic evidence of the construction area that is very clear, and I would like to point out Whaley has offered evidence that the work it did was above, that did at the time in question, was above the silt fence. Whaley didn't mark on that photograph where the fall occurred. Whaley sent the photograph to the plaintiff and said, "You tell us where you fell." The plaintiff indicated the area where the road sign was allegedly located, and it is clearly outside the line of demarcation between where Whaley was performing services and the area of the median where Whaley had not worked or not controlled services, the area that Whaley did not control. I guess I would like to conclude my argument by wrapping it back where I began, and that is with the difference between, the fundamental difference between allegations or theories, or as the plaintiff calls it, possibilities, versus evidence that is necessary at summary judgment in order to establish those theories to a point that they can be submitted to a jury. Rule 56 is very clear. Cases don't go to a jury unless you proffer evidence to support those possibilities. Here, plaintiff's theory is, well, Whaley Construction was doing some work nearby, therefore it's their fault that a signpost was cut in a different area. A different theory would be that a car had hit a sign and knocked down the signpost and left a portion protruding. A different theory would be that a storm has come through, as they sometimes do, and taken out a sign, and the sign had been removed. I suppose a theory could be that whoever was mowing in the area could have hit a sign. There are innumerable theories as to why the signpost was there. It is the plaintiff's burden to show that Whaley Construction created it, and the fact that they happen to be doing construction in a different location in this median does not mean that they created or controlled this signpost at issue. At summary judgment, plaintiff is required to establish facts through admissible evidence to support the theories. Here, the plaintiff failed to meet the procedural requirements of Rule 56 in failing to, under 56.03, point out evidence to place facts in dispute, and perhaps more importantly, failed to meet the substantive mandates of Rule 56. For those reasons, the trial court correctly granted summary judgment. And if the court has no further questions, we would just ask that the decision of the trial court be affirmed.
I hear none. Thank you. We'll hear from the appellant in rebuttal.
Thank you, Your Honor. Your Honor, in rebuttal, I must take issue with limiting Whaley's responsibility to just an area where a silt fence was. The area was in the same median where construction was being conducted and under the control of Whaley. And to simply take an assertion that we're only responsible for in the silt fence when there is, we would submit a dispute of fact based on the declaration, makes that a dispute of fact worthy of a jury deciding and not the trial court. And again, that's our position, and it's for those reasons that we'd ask this court respectfully to overrule the position of the trial court and send this back for a trial. Thank you.
Thank you. We appreciate the argument and briefs from both sides. If you would please adjourn court till our next regularly scheduled docket.